Field, Principal Reporter against Kay and others.
Ms. Scott.
Lords and Ladies, we've opened this appeal. This is an appeal, Lords and Lady, about a parent's right to be heard.
Could you be just a little closer to the microphone? I think it's slightly...
Maybe I'll have to move this way. Is that
easier?
easier?
That's better, yeah.
Very well.
Good, thank you.
Well, this is an appeal about a parent's right to be heard, or in terms of the European Convention on Human Rights, to be involved in the decision-making process in relation to his child. And I should advise, my lords and my lady, that that parent is seated in court and is obviously very concerned about being involved. But the sad thing, of course, is that while he can sit in this court and listen to what I have to say, the decision-making process in this case is taking place in the children's hearing in Scotland, and that is a place where, subject to my lords and my ladies' decision, he does not have a place at the table and cannot be involved. The appellant seeks orders from this court which will allow him to go back to the children's hearing. He either seeks a reinstatement of a sheriff court order that allowed him involvement and or the reading down of the requirement for such an order which failing a declaratory of incompatibility.
Yes.
I propose to argue the case subject to my lords and my ladies' directions in relation to 5 propositions. And they are these: that the Court of Session, that is the outer house and the inner house, erred in holding that an order by the sheriff that entitled the appellant to be involved in the children's hearing was not competently granted. My second proposition is that the requirement to secure such an order as a prerequisite of being involved in the children's hearing is a violation of his rights in terms of Article 8 of the Convention. Third, that the requirement to secure such an order is a violation of his rights in terms of Article 14, read with Article 8. Fourth, that requirement has prevented the appellant from having a fair hearing within a reasonable time in the determination of his claim for parental responsibilities and rights and contact in violation of Article 6. And fifth, that Section 93(2)(b) of the Children's Scotland Act of 1995 should be read down in terms of Section 3 of the Human Rights Act of 1998, which, failing, my lords and my ladies, should grant a declaration of incompatibility in terms of Section 4.
Yeah.
So, though that's my position in a nutshell. Do my lords and my lady wish to be taken to the Children's Scotland Act of 1995? Would that be of assistance? I'm conscious that some members of the court are very familiar.
Some of us may be, but I think to get the basic structure, yes, it might be helpful if you could do it quite briefly, but just give us an introduction to it. And we should find it in the bundles first.
The relevant act. And it might help if I just point out the structure in terms of tab 10.
So the tab number is?
10.
10. Good.
The section that we're concerned with in this case is section 93(2)(b), which is towards the end of the tab. It's on page, in the reprint K 400/3. And the part that we're looking at is on K400/5, the definition of relevant person. A relevant person in relation to a child means A, any parent enjoying parental responsibilities or parental rights under Part 1 of this Act, B, any person in whom parental responsibilities or rights are vested by or under or by virtue of this Act, C, any person who appears to be a person who ordinarily, and other than by reason only of his employment, has charge of or control over the child. Now that's the relevant person we're concerned with.
And it's B that's the particular bit, is it, that we're interested in?
It's A or C, not so much B, because we're dealing with a parent here.
Right. I see. Yes.
Now, the relevant person is a key phrase, and without taking my lords and my ladies to the relevant sections, a relevant person is the person who's entitled to be involved in the children's hearing. The relevant person has the right to be at the hearing in terms of section 45.8, and an obligation to be there unless his presence is thought to be unnecessary or unreasonable to require it.
So that was 45.8.
45.8.
Yes.
And the process of the hearing,
that was the right to attend, is that right? And the other one was which one? Sorry.
45.8a is the right to attend. 45.8b is the obligation to attend unless the hearing thinks it's unreasonable to have you there or your presence is unnecessary.
And if the system works properly, as you say it should, that would mean that the father would be there from the very beginning.
Absolutely.
So there'd be no need to go to a sheriff
Absolutely.
to get an order. It would simply be that the right would be established from the very start, and the whole system would operate with him as a right to be heard from the beginning.
And it will be my submission that's absolutely vital, because if one looks at the process here, the children's hearing convenes. It discusses in terms of section 65 with the relevant person whether the grounds for bringing the child into the system are established. The relevant person can say yes or no. If the relevant person says no, the facts go off to the sheriff to be established under section 68. And if established, and only if established, they come back to the children's hearing for a determination of what's to be done in the interests of the child in terms of section 69 and 70.
I wasn't quite clear about one bit of history in that respect. The grounds were denied, I think, by the mother. Is that right? Okay. And then they went to the sheriff, but then without any evidence, it looks as though concessions were made, and it was simply held to be established. But I suppose your point is, well, there's obviously an issue as to facts alleged so far as the father is concerned, and they were never tested. Indeed
so. And in fact, facts that the mother disputed were taken out when the matter got to the sheriff court, albeit she doesn't seem to have been there.
Yes.
And facts that were left related to the father, and he had no opportunity at all to dispute those or to deal with them.
So, Mr. Scott, could you just direct the attention to the bit of section 65, which is relevant also?
Yes. It's subsection 4 and 5. It's the duty of the chairman of the hearing to explain to the child and relevant person at the opening of proceedings on the referral the grounds stated by the principal report of the referral in order to ascertain whether these grounds are accepted in whole or in part by them. And then if one works one's way through the section, the issue arises as to whether those grounds are accepted in whole or in part. And in terms of subsection 7, if either or both of the child and relevant person do not accept the grounds, the hearing directs the reporter to make an application to the sheriff. And then there's another issue which relates to the child who's too young to understand, which would also have applied in this case. That's in 9.
Sorry, subsection 9?
Subsection 9 of section 65.
Yes.
And the matter goes off to the sheriff under either of those bases. But when it arrives at the sheriff court, if the relevant person accepts the grounds, notwithstanding the child's non-understanding, the sheriff can deem the grounds established and return the case to the hearing. So the sheriff at that point has a supervisory role in relation to the grounds. But only the relevant person has the key there.
So I mean, you know these sections so well, Mr. Scott. I wonder whether you could just direct our attention to where that is.
That's in section 68, my lord. Yeah. And it's at section 68.8. Where in the course of a hearing of an application under section 65.7, that's the section which relates to non-acceptance, the child and relevant person accept any of the grounds of referral to which application relates, that's before the sheriff, or B, under section 65.9, which is where the child's too young to understand, the relevant person accepts any of the grounds of referral to which the application relates, the sheriff may, if it appears to him reasonable to do so, dispense with the hearing of evidence relating to the ground, deem the ground to be established for the purposes of the application, unless he's satisfied in the circumstances of the case the evidence should be heard. And then, in terms of subsection 10, he remits the case or she remits the case to the principal reporter.
So although every case involving a young child has to go to the sheriff,
Yes.
once you get before the sheriff, the relevant person can put their hands up and say, I accept we ought to be back in the children's hearing.
Exactly so,
Yeah.
lady, yes.
65(9) and so on, is that right?
Yes.
Is that the only provision that dispenses with the hearing of evidence?
Yes, it is. It's in section 68, and it's the provision I've just read out.
Yes, but there's no other circumstance in which the sheriff may dispense with
No, there aren't.
receipt of evidence.
No.
But you I suppose, if going back to the beginning, if there's no question of dispute, it doesn't go to the sheriff at all. Is that right?
It would have in this case, because the child was too young to understand.
Yes.
Oh, I see.
That's 65(9), isn't
Right.
it?
Yes. This case arose both in terms of 65(7) and 65(9).
Yeah.
For both reasons, the matter was before the sheriff.
Right.
But in either event, once the relevant person agrees that the facts and the grounds are established, the matter goes back to the children's hearing. And of course, one of my key issues here is the father was not present and was not entitled to take part at that stage.
And yet the result was an order that he wasn't allowed to see his child.
Well, in the final outcome, absolutely, my lady, yes. Surprising as that may seem. There's one other thing I should perhaps mention before leaving this part of the Act. The children's hearing makes a supervision requirement in terms of section 70, but that requirement can last for only a year before it's reviewed. This is not a long-term order. It's designed to be reviewed at least annually in terms of section 73 and should not persist for longer than is necessary. And that's perhaps something that may raise concerns when we come to the events in the hearing.
I'm sorry to ask this question. It will no doubt not for the first time expose my utter ignorance of this, but under section 69(8), the provision dealing with dispensing of the hearing of evidence, in order for that to be triggered, the relevant person obviously has to accept the relevant grounds for referral. So the father in this case, not being a relevant person, didn't have the opportunity to accept.
Absolutely.
Yeah.
Yes. Yes.
So he was deprived of that facility as well.
And that stage is crucial to the hearing because that is the basis upon which the hearing is going to proceed for the remains of that referral.
So, Mrs. Scott, it's not your fault, but my copy skips a page. It goes from 385 to 387.
Yes, I realised that in course of preparation, and I asked for a copy of 386 to be presented
thank
to
you
the
very
court. And my apologies.
Thank you. No, thank you very much.
Should be doing it electronically. Should be doing it electronically.
So which page is missing?
386. It misses the first part of section 69,
Yes.
which has the matter going back to the hearing
That's
and the hearing
right.
being authorised to make a supervision requirement.
Yes, 69. Can you just guide me on this? Is it a once and for all opportunity, so far as the father is concerned? I mean, if once the sheriff sends it back, that's it, is it?
Yes,
Is there any route back to the sheriff and say, oh, by the way, there are grounds we want to have looked at again, or is it just?
Well, that's it as far as the referral is concerned. Unless, of course, one goes back in under Section 85, but that would be such a rarity. That was the matter that followed the Ayrshire case and allowed some way back. But for as far as this is concerned, that's it as far as this referral is concerned.
Well, you can have a review, can't you, under Section 85?
Yes, you can, but that's relatively rare, and you can only do it if you're a relevant person. There's one instance of a gentleman from Wales trying to seek a review because he hadn't been treated as a relevant person, and that didn't work. I think that the case is D against principal report. I'm not sure of the tab number. But normally that's it.
But how would the review work? The idea is there's new evidence.
Yes, it's
But
new evidence.
I mean,
yes.
the scenario might be that the let's assume the father says, well, I didn't take the advantage of the opportunity to have the evidence reviewed. There's evidence which I should have asked for but didn't ask for to be led. I'd like it now to be considered. Can he do that?
I think I'd have to go back to section 85. It wasn't an issue which arose in the course of this case.
Reasonable explanation for the failure to lead such evidence on the original
Yeah.
application.
Yes, exactly.
So it's reasonable explanation.
But only a relevant person or the child can
Exactly
ask
so.
for a
And
review.
of course, one of the problems here is by this stage, time has passed and
Yes.
one has missed out vital stages of one's child's life and so on. Time is of the essence, of course, in any matter relating to a child because they're growing and developing and missing contact. Or,
What age is the child now in this case?
The child was born on the 6th of May 2002, so she's now 8. And the father hasn't seen her now since August 2007.
2007, I think, yes.
Or the way we could put it is that she hasn't seen her father.
I'm grateful, my lady. Absolutely, yes.
Yes.
Now, the other part of the Children's Scotland Act I should direct my lords and lady to is part 1. This Act is organised into a public law, using a very general term, section in part 2, which deals with public intervention in the life of the child, and part 1, which are relationships between parents and the child. And in section 93.2b, we have a link between the two, and that's the link which I am actually attacking in the course of this appeal. But if one looks at the first part of the Act, this Act opens by attributing certain parental responsibilities, and it describes those parental responsibilities in section 1.1a as the responsibility to safeguard and promote the child's health, development and welfare, to provide direction and guidance, to maintain personal relations and direct contact, and to act as the child's legal representative. And those combination of responsibilities are referred to in subsection 3 as parental responsibilities, in quotes. So that the whole package is our parental responsibilities. And they supersede any analogous duties imposed on the parent at common law, but without prejudice to any other duty so imposed on him or any duty imposed by or under by virtue of any other provision of this Act or any other enactment. So it supersedes common law responsibilities, but not statutory responsibilities.
So the duty to turn up at a children's hearing as a relevant person, one might think might be a parental responsibility. It's a responsible thing to do, isn't it, to turn up at a children's hearing?
Absolutely.
To take part in a discussion about what's going to be best for your child?
And I would argue a fundamental part of safeguarding, promoting the child's health, development and welfare.
So it's right back to section 1A, section 1A.
Yes, directly. And also indirectly, if a child is subject to a supervision requirement, indirectly through the hearing, one is looking at direction and guidance to that child. And I'll come on to Kilbrand and measures for education. And of course, the hearing holds the key in certain cases, and in this case, to maintaining personal relations and direct contact with the child. And then in terms of the Act, parental rights are there in order to enable a parent to fulfil parental responsibilities. And so in terms of 2.1a, the first parental right is to have the child living with the parent, or otherwise to regulate the child's residence. Second, to control, direct or guide in a manner appropriate to the stage of development of the child's upbringing. And of course, that will be pertinent to what was happening in a children's hearing. Third, the right to maintain personal relations and direct contact, and fourth, to act as the child's legal representative. And those rights together are described in subsection 4 as parental rights. And again, they supersede common law rights, but are without prejudice to statutory rights. Subsection 3 tells us who has the rights. A child's mother always has parental responsibilities and rights. A child's father has rights in terms of 3.1b if married to the child's mother at the time of conception or subsequently. And that section has been extended, was extended on the 4th of, with effect from the 4th of May 2006 to allow fathers who had registered the birth jointly with the mother to have parental responsibilities and rights. That was a result of the Family Law Scotland Act of 2006. A father may also have...
So we don't have that actually printed in here, or is it?
It is actually printed in
Sorry,
one of
where
the
is
tabs.
it?
It's not printed in this volume, no.
It's, no, the amendment is inserted. 1A, subsection 1A is inserted.
Yes. Sorry.
So where do we find it? Where's it the most convenient from?
Do you want to have that in?
Sorry, where is it? Maybe I'm looking at the wrong thing.
I'm looking. I've got a photocopy of the Parliament House book, which I think matches what we've got in the bundle.
No.
It should be page 342.
No, I'm not looking at that. Oh,
Oh,
the page I'm looking at is not from, doesn't look as though it's come from Parliament House book for some reason.
Tab 22 shows the update, if the Lords wish it. It's section 23 of the 2006 Act.
yes. I see. Yes. So that's. Yeah.
Is there some reason why part of this has been printed off from the Parliament House book and some is not?
I'm advised it was because it was thought appropriate to put before the Lords the original version of the Act as it stood before the amendment, and then to put in, show my Lords the amendments, and Lords and Lady the amendments separately.
I see. Well,
At the time of the
for good or
original
ill,
referral.
what I've done is to photocopy the Parliament House book, including the amendments. But you'll have to make sure that my attention is drawn to the changes. But it's very obvious, actually, this particular one, because it's quite clear that section 1A, subsection 1A, has been inserted, and there's a footnote that tells you how it's been done.
At the time of the original referral, of course, this was the legislation
Yes,
which stood.
absolutely.
Yes.
And
absolutely.
therefore, I think that's why it's been
Yes.
dealt with separately to show my Lords and my Lady that this was the original position,
Yes.
and the position has subsequently changed. Because one of the awkward things about the change is that in Scotland now we have some families where the father is the relevant person for one child, for the younger child, not for the older child.
Yeah.
It's very strange. I'm not sure why it wasn't made retrospective, but there we are.
Well, my argument will be that there was no need to link relevant person to parental responsibilities and rights in this quite this way, and it's resulted in all sorts of
I
problems.
see. Yes. Well, that would make sense. Yes. Right. So we've got as far as section 3.1b.
Indeed. The other matter I should draw to the court's attention is 4, where an unmarried father can secure parental responsibilities and rights by agreement with the mother. This was an innovation of the 1995 Act, a registered agreement between the parents.
I think I invented it.
And it's of course been extended for the unmarried female, for the unmarried second female parent now, in terms of the 2008 Act. Now, if an unmarried father such as the appellant does not fall within any of these categories, and of course ours doesn't, he has to go along to the court if he wants parental responsibilities and rights in terms of section 11.
Yeah.
And this is the power of courts to make orders in the relevant circumstances, in proceedings in the Court of Session or Sheriff Court, whether those proceedings are or are not independent of any other action, an order may be made under this subsection in relation to parental responsibilities and parental rights. And then if we jump over 1A, the court may make such order under subsection 1 above as it thinks fit, and without prejudice to the generality of that subsection, may in particular make any of the following orders. So these are examples of orders. They're not limiting the orders that the court may make.
Is this an order which they could make the sheriff could make on a reference?
It's never been done, never been read that way.
Why not? I'm just asking.
I don't think it's ever it never occurred to anybody to do it. Of course, if a father is not present at the reference, it would be quite difficult to do because he wouldn't be there if he were not a relevant person. It becomes a bit circular.
Maybe not an action. I don't know how actions.
Yes. It may not be. The parts of subsection 2 we're
Yes,
perhaps
proceedings.
concerned with are...
Proceedings in the Sheriff Court.
Yeah.
Proceedings
So
in
you
the
do it
Sheriff
off-
Court.
Yes. I mean, that...
Seems very strange. I mean, I was just asking whether it could be
Yes.
done.
Well, I can only say it's never been done, and no doubt no friend for the reporter will be able to advise the court further on that.
Can I ask about this? Because the equivalent orders in England and Wales can be made either on an application, or at least not all of them, but most of them, or of the court's own motion in the course of other family proceedings. I think that was what my lord was getting at.
Yes, I
But, yeah.
And, my lady,
Yeah.
this is the same in terms of subsection 3.
Yeah.
Subsection...
Subsection 3 does refer to applications.
Yeah, but there is something
Yes,
which says...
3B,
Yeah.
although no such application has been made, the court, even if
Yes.
it declines to make any other order, considers it should make an order. So that is open to the court in any application. I think my concern would be that the court's not likely to do it in a referral where the father is not considered to be a relevant person because he's not going to be there.
Yeah, you may be right, Mr. Scott. I was just asking whether it would be competent to do it. You know.
The answer, I think, must be yes.
Yes.
The only time I've ever proposed it would be in an adoption proceeding. That's the only time I know of it actually having happened. In this case, we're concerned with imposing responsibilities and rights on a person in terms of 2B, potentially. Contact orders are in terms of D. The court may make an order regulating any specific question which has arisen or may arise in connection with any of the matters mentioned in subsection 1, and that's a specific issue order. And then we've looked at 3. And in terms of subsection 13, orders include interim orders. Now, I perhaps should go back to the test for making orders,
Yes,
and that's 11.7.
yes.
And in terms of the Act as originally drafted, 11.7 set out what's been referred to as the overarching principles. And they are that the welfare of the child is the paramount consideration. No orders should be made unless it's better for the child. And that was to depart from the practice where orders were made in every case in a divorce. Parents were to be left to get on with matters if they responsibly could. So no orders unless better for the child. And then take account of the child's views. Obviously, that's the section which arises from the obligations in terms of Article 12 of the United Nations Convention on the Rights of the Child. Those sections have been elaborated in the 2006 Act in relation to allegations of abuse and matters of cooperation, but nobody has argued in this case to date that the elaboration has any impact on the outcome of this case.
Yes.
Those are the principal legislative provisions. Before I turn to my propositions, if I may, with my lords and ladies' permission, can I make 3 observations as to the facts? That is that the present case arises before the court against a changing social background that is relevant to the interpretation and application of the European Convention as a living instrument. The fact that the appellant and the child's mother didn't marry is, of course, not uncommon now, and there are population statistics reproduced in the appendix at pages 205 to 236. I don't think I need to take the court to them because the facts are fairly stark. In 1977, only about 10% of births were to unmarried parents. By 1997, that figure was about 38%. In 2007, it was 49%. In 2008, it rose to over half. So over half of Scottish children are now born to unmarried parents. And if one wants to extrapolate back to 2002 when this child was born, my researches would indicate it's about 43% of children were born to unmarried parents at the time this little girl was born.
How specific is this as to location?
Scotland. It's Scotland's population statistics.
Just generalist for
Yes,
Scotland?
it's not UK, it's Scotland.
Yes.
I'm sorry, the 38% was for which year, please?
1997, Lord.
1997.
And 1977, I forgot to write that.
10%. 1977, only 10%.
Yeah.
And of course, I'm going to go at some point to Zornega and the court's observations on the changing European position on this. The second point to make generally on the facts is that this is not a case where there can be any argument at all about the appellant's entitlement to respect for family life. It just doesn't arise in this case. He was living with the mother before the child's birth. There was a family unit consisting of the appellant, this child's mother, her child by a previous relationship, his child by a previous relationship. There was a family unit of 5 for a period. These parents registered the birth together. That's at page 72 of the appendix. This child sadly was very seriously unwell in her early years with a retinoblastoma, and both parents were involved in the medical treatment of the child. The father stayed in hospital with her. Following separation, when the child was 1 or 2 years old, the father had contact until she was 5. He was involved in her medical treatment. He was the person who the hospital called when the mother failed to take the child for her chemotherapy. He was involved in her education. He was the person who the nursery called when the child wasn't taken to nursery by the mother. And there really is no issue about the de facto family tie, so we don't need in my submission to go to Bink or to Keegan to set up that case. The third general point is in relation to the proceedings. If I might just briefly describe to the court an analysis that these proceedings can be divided into 4 stages. At stage 1, which ran from May of 2004 to March of 2006, there was a straightforward sheriff court action where the appellant was looking for parental responsibilities and rights in relation to his child. And it was resolved, as are, I think, the majority of these sorts of cases in Scotland, at a child welfare hearing. Now, that's a hearing that the sheriff is bound to fix right at the beginning of the case to identify the issues and see if he can resolve them. And Sheriff Totten, who is the sheriff involved in this case, did that, and matters were proceeded on the basis of Sheriff Totten's order. Now, I should just pause and say that Glasgow, as the biggest sheriff court in Scotland, set up a specialist family court.
Yes, I just wondered how this worked, because there are a whole series of interlocutors in the bundle with different sheriffs' names. Yes. But can we take it that Sheriff Totten was the responsible sheriff so far as this case is concerned? I mean, is it specific as that?
No, it's not, my lord. I wish I could say it were. The Glasgow Sheriff Court, I think, has 4 designated sheriffs at any one time for its specialist family court. And so if you have a case such as this, your child welfare hearing is going to be dealt with by one of those specialist family sheriffs. It's not like other courts where it could be any sheriff.
Yes.
Although I know some courts do try and keep it to the same sheriff. They recognise that there needs to be continuity. But in Glasgow, it's the small group of designated family sheriffs.
Well, is Sheriff Totten one of those?
Yes, he was. He was one of the first, I think. He was in place from about 2000, 2001.
So there's a 1 in 4 chance it would get back before Sheriff Totten.
And it very regularly did, as my lords and my lady will have seen from the interlocutors. Yes. And in fact, the disputed interlocutor in this case was Sheriff Totten.
Yes, of course.
So that's stage 1. Stage 2 in my submission runs from March 2006 to August 2007. And at stage 2, there was children's hearing involvement, but the action continued in the sheriff court.
Really? How interesting.
The referral to the children's hearing was triggered by concerns about both the parents, and we've looked at why the appellant wasn't regarded as a relevant person.
So the social workers picked the case up and they referred it, but it was as a result of things
Well, the father referred it to the social work department because he was concerned about the mother's care of the child, ironically. Mm-hmm. And there was a referral to the children's hearing. And the children's hearing and the sheriff court ran in tandem. Now, of course, the fathers missed the early stages of the hearing, but notwithstanding that the matter was before the hearing, the sheriff continued to exercise his jurisdiction in relation to parental responsibilities and contact. And if one looks, perhaps it might be worth just looking at the interlocutors at this point. The matter is revived at page 103. And this is about the time of the referral to the hearing. At the time of the referral to the hearing, Sheriff Totten on page 104 suspends interim contact and appoints a reporter. He appoints Miss Kelly, who is now the curator, to go and inquire into the facts and circumstances in relation to the child. And he continues the child welfare hearing. And the matter runs on while Miss Kelly investigates. There's a reference to a social...
Was that suspension because of the allegations against the...
Possibly. I'm not fully...
You don't know?
I'm not sure. But in any event, Miss Kelly is asked to investigate. There's a reference to a social work report on the 25th of May, which I don't think is a social work report. It seems to be Miss Kelly's report. And we carry on until the 18th of August. And on the 18th of August... we have Miss Kelly present as the reporter. She's appointed as curator ad litem to the child. And on joint motion, everybody's agreed, finds the pursuer entitled to interim contact with the child each Saturday from 10 until 12, contact to take place within the contact centre. So everybody's agreed on the 18th of August that there should be contact. Now,
Who was the sheriff on that occasion, please?
That was Sheriff Bowman.
Bowman.
That was another of the sheriff, the family court sheriff.
Is she also one of the...
Yes, absolutely. Now, in the meantime, of course, this child has been referred to the children's hearing, and the father, and this is in the Statement of Facts and Issues, is not permitted to enter the children's hearing, at least initially. We have the establishments of the grounds of referral. And then if we look at what's happening in tandem in the children's hearing, on page 160, this is the hearing's reason for its decision, recorded in writing from the 19th of October 2006. What the hearing says at the foot of the second paragraph: contact at the moment was through a court order, and the panel felt it was appropriate to leave it as it is.
Yes.
So the panel's leave it, the children's hearing is saying, right, the sheriff's got control of the contact, we'll leave it. But of course, the father wasn't entitled, as it was thought, to be present at the hearing. He was there on sufferance, as it were. And so when the matter goes back to Sheriff Totten on the 27th of October, and this is on page 108.
Sorry, 108?
108.
Yep.
Just 8 days after that hearing. The sheriff, having heard the curator ad litem and agents of both parties, grants the pursuer's motion number 7.2 in part, and that was a motion for parental responsibilities and rights, conjoined by the curator ad litem, despite the defender's opposition, and in terms thereof, grants the pursuer parental rights and responsibilities to the extent he becomes a relevant person in the children's referral relating to the child. Continues interim contact previously granted.
And that's the interlocutor addition.
That's the one, yes, that's the disputed order. Yes.
Do we have that motion? I mean, was there something in writing? Or was it just oral?
It's not in the bundle. It's understood to be a motion for parental responsibilities and parental rights, which wasn't granted in full. The curator ad litem's case sets out the circumstances rather more fully, and if the Lord wishes to hear from the curator's counsel, she can explain that in more detail.
I see if I've grasped that. The motion would be asking for parental rights in general?
Parental responsibilities and rights in general.
In general.
And the sheriff didn't grant them in general.
No.
The sheriff granted them in a restricted form.
Basically made a specific issue order in a way.
Well, I hesitate about that
Yeah,
because
I
I'm
wonder.
conscious that there was a decision of Lady Peyton that says you can't make a specific issue order saying somebody's a relevant person. So what the sheriff has done is granted parental responsibilities and rights, and I would say that's for parental responsibilities and rights as defined in sections 1 and sections 2, that limited or restricted the opportunity for their exercise to the children's hearing.
So, I'm sorry, but when it says in part, what does that mean?
He didn't grant the whole of the order requested by the appellant. The appellant was looking for all parental responsibilities and rights. He was saying to the court, please put me in the same position as a married father. And the sheriff said, no, I'm not going to do that. I'm going to grant a restricted order. And that was the restriction. That's as I understand it.
Well, I'm not clear what the restriction was.
The restriction was to the extent he becomes a relevant person in the children's referral.
Oh, I see.
Yes.
Right.
Does one have to get some flavour for the restriction by looking back at the scope of the orders the sheriff could have made in the list?
Indeed. Yes, possibly.
And it's not one of the ones that's specifically described in subsection 2, but you say that's all without prejudice to the generality of the opening words.
The sheriff has complete liberty to make the orders that are appropriate in the interests of the child.
Yes.
But pragmatically, was this for the purpose of making sure that he was entitled to attend the children's hearing?
Absolutely, absolutely. It was recognised that he should be there, as I understand the purpose of that order.
So he came along hot fruit from the 19th of October saying, I wasn't able to.
He was there.
He was there, was able to take part.
Yeah, on that particular date, on sufferance, having been kept out on previous occasions. And as I understand it, there was great concern that, albeit he'd been allowed in on that occasion, he might not be allowed in the
again.
future.
Well,
He had no
that's
right
right,
to be there. And in order to protect his position, he needed to be able to address the hearing. And I'll come on in a little bit more detail in a moment to why he needed to be able to protect his position.
Can I be quite clear, though? He was present, but not present as a relevant person. So did he have any right to participate, say anything?
No, he was allowed to participate.
He was
But
allowed.
if one looks at this, yes, in fact, they were all there on that particular date.
Yeah.
Yes, yes.
But if objection had been taken to his presence,
Yes,
who knows what might have happened.
precisely. And the relationship between the parents was quite volatile, and there were protests from time to time. Of course, it comes against a background that on the first occasion he turned up at the hearing centre and been told, you can't come in, you're not a relevant person.
I suppose in a strict reading of the legislation, the validity of the order, or not the order, but the permission to that he be present and participate might have come under question.
Possibly, yes. His participation could have come under question. There's a provision which allows the chairman to allow persons in, but they if one looks
Where is
at-
that? Where is that
That's
from?
at the Children's Hearing Scotland rules. This was something which was discussed in the course of the hearing for the division as to whether this would be a satisfactory solution, and the division determined that it wouldn't be a satisfactory solution because he wasn't entitled to
No
participate.
entitlement, no.
Yes, he wasn't entitled to be part of the discussion if allowed in by the chair.
Tab 12.
Thank you very much. Tab 12.
I'm looking at section 43, subsection 1. Is that the relevant one to 9?
Lord Lutz allows me to have that one as well. Yes, well, that's the general position, and the regulations which deal with that are in tab 12. They're part of the children's hearing rules. And rule 13, this is in tab 12, allows the chairman to permit somebody to be present whose presence is justified by special circumstances.
Yes.
And that has been suggested in the past as being something which would allow an unmarried father to be there. But of course, it doesn't allow him to take part in the discussion because he's not a relevant person in terms of Rule 20. And he can't appeal, as Malone Jr. points out.
Is there any jurisprudence as to what is required in order to meet the stipulation that there be special circumstances?
There is one authority which I'll come to, which is L against H, which was a suggestion in the context of somebody trying to become a relevant person that he might be allowed in. The drawback of the Rule 13 position is, first of all, you don't get the reports in advance, and we've already got a problem from Michael on not getting reports in advance, which means you can't participate properly in the hearing. Second, you're not allowed to discuss the matter strictly in terms of Rule 20. And third, you're not allowed to appeal because you're not a relevant person.
As regards what happened on the 27th of October, you've referred to what the second minuter, the curator, has said in the case.
Yes.
I mean, and that we find at page, the relevant part, I think, is at page 3 of that case. I just would like to know whether this, first of all, whether you accept that this is what happened. What is said there, and I'm looking at page 3 at letter E. The sheriff, having heard submissions, determined that it was in the best interest of the child that the appellant participate in the decision-making process of the hearing, and it was better for the child if an order be made. It is sufficient for the competent... well, I think that's what is said happened, and that the sheriff determined that the appellant's participation in the hearing would contribute beneficially to the child's welfare. Now that accords with your case, does it?
It does
as to
indeed.
what happened?
Now the difficulty I have is that the agent present and representing the appellant is a different agent to the agent who now represents him. She passed the matter on when she felt she was getting out of her depth. But as I understand the appellant's recollection, that is correct. The difficulty for all of us present today is that the curator was clearly there and has a recollection, and she's able to assist, and possibly the mother's counsel is able to assist. But the agent instructing me wasn't there. That is my understanding,
Yes.
subject to that qualification.
Thank you.
Yes.
It's apparent then that matters didn't entirely run smoothly, and there were some ups and downs with this contact order. But the final straw came, if I can put it that way, in August 2007. And that is when my stage 3 begins. Because in my submission, in August 2007, the children's hearing assumes sole control of the issue of contact in particular. The decision-making moves from the court to the hearing.
Where do we see that?
One sees that, my Lord, at pages 116 and 117 to start with. This is in the case. There had been an incident at the contact centre. The father had taken the child out of the contact centre and the mother was concerned about that. And what happened was the matter came before Sheriff Platt on the 3rd of August 2007, and he revoked the contact order and he set up the case in the Sheriff Court for a hearing. He put in place a child welfare hearing for the 31st of August, but more importantly, he allowed defences to be lodged and set up an options hearing. That's the case management hearing in the Sheriff Court, where one looks at the final pleadings and decides if one's going to have a proof, how long it's going to be, and so on and so forth. So what the Sheriff does on the 3rd of August is set the matter up to proceed to a proof on evidence.
In the Sheriff Court.
In the Sheriff Court.
Yeah.
But if one looks at the very next page, that completely falls on the 31st of August. He discharges the options hearing and he assists the cause.
I see.
And the reason he does that is that the children's hearing have assumed control.
And is that the normal order made if the matter is to be transferred to the children's hearing? If there are proceedings going on in the Sheriff Court, there's no point in their running in tandem. and therefore assist would be the appropriate order?
And more than no point, it becomes, and I'll make this argument, the sheriff really can't make any orders once the children's hearing have assumed control.
What are the powers? Can you just show us pointers to the sections which deal with that?
There is no, it's case law rather than a particular power. And I'm going to refer to Aitken and P against P and the authority reporter against S. But the direction from the inner house is once the children's hearing have assumed this control, then it's inappropriate, and I think my Lord in the Chair will recall mentioning this in F against F.
Yes.
It's inappropriate, and what the division says is in that respect it could be said to be incompetent.
How does one know that the children's hearing has assumed control?
Well, if I take my Lord to the decision of the hearing, which occurred between those two dates, then my Lords can see, Lord and my Lady can see what's happening. And that's at 161.
Sorry, which page?
161.
Oh, yes. So what date are we...
This is undated, but it's agreed that this is a note of a hearing that took place on the 13th of August 2007.
The father was present again.
The father was present, yes. Well, by this time, of course, the disputed order had been granted and he was being recognised as a relevant person. So he's there, and the allegations are referred to. Mr. Keeney refutes the allegations. He states he's willing to cooperate with the assessment performed by the social work department, requested he should continue with a contact order in place on the supervision requirement. He's happy voluntarily to cooperate with the assessment, there being no contact with his daughter. Requested didn't want this to be a formal condition on Lee Shell's supervision requirement because it may prejudice any future decision on future contact with her. He wants as much contact with his daughter as possible. Up until recently, he had supervised contacts with his daughter through a court order, not through the children's hearing system. And so on. And it's noted that the court order has been suspended, and then over the page, the panel then moved to make their decision. The panel unanimously decided to continue the supervision requirement, terminating contact with James Keeney. We asked for an early review in 6 weeks to allow the social work department to complete their assessment and give us a report, and so on. But what happened on that date was that the supervision requirement imposed a condition that there should be no contact between the appellant and his daughter.
It was continuing it. When what was it? Is this? Do you mean they're adding? When it says continue it, terminating the contact, what does that mean?
They continued the supervision requirement, but imposed a further condition that there should be no contact.
Okay, so that's an additional bit. Yeah.
Yes.
Now, I'm trying to trace back the history. Had the hearing made a contact order before? The sheriff had revoked it, as we saw earlier.
Just a few days before,
Yes.
effectively, 10 days before this hearing,
Yes.
the sheriff had suspended the interim contact order.
And although this sheet is undated, we know it's the 13th.
Indeed, yes, we're agreed it's the 13th.
Yes.
Sorry, 13th of which month?
13th of August. So it occurs 10 days after the sheriff's decision of the 3rd of August and a couple of weeks before his decision of the 31st. And this is, in my submission, a pivotal point because the hearing deals with contact and terminates contact. It says there shall be no contact.
But the original purpose was to enable a period of peace and quiet so that it could be a full social work assessment.
Absolutely, absolutely.
Yeah,
Yes,
it wasn't meant at that stage as a final termination.
Absolutely, and
the
I'll come on
relationship.
to what's happened. Perhaps I better do it now. What happened following that was that on the 17th of January, which was the next substantive hearing, we have a hearing where social work come along, and this is on page 164.
Yes.
Social work were recommending termination of the supervision requirement as there are no concerns regarding her welfare and the care of her mother. She appears to be thriving, and according to the mother, her behaviour has improved considerably. There's ongoing family support work being carried out with the child. The panel questioned the mother and social work regarding the recommendation to terminate the supervision requirement and the possible impact this may have on the no contact Mr. Keeney, which is at present in force. It was pointed out this could lead to Mr. Keeney going back to court to ask contact re-established. Mrs. Roger expressed her concern regarding him having contact with the child due to previous allegations and so on. And the social work then seemed to change their position at the foot of the page. Social work expressed the view that during the hearing, supervision should continue and no contact with father should remain in place while family support work is ongoing. The panel listened to all present, made a decision to continue the supervision requirement with the condition that there is no contact. So what the hearing have done here, and I'll explain this with reference to the law in a moment, is said, well, if we terminate the supervision requirement in terms of it no longer being required under Section 73, that immediately means that the father can revive his application for contact in the Sheriff Court. We don't want that, do we?
Right, yes.
And we'll continue the supervision requirement. So this is a supervision requirement which appears to be continued on the face of this decision expressly to prevent the father going back to the Sheriff Court.
Supervision of contact that wasn't allowed to take place.
Exactly. Precisely. And I'll come to why it was that the hearing were able to state that position in that particular hearing, but I'll finish the story first in relation to what's going on here.
Can I apologise? I'm not quite sure why the supervision requirement prevents him going back to the Sheriff Court. Can you just explain that there must be a provision somewhere that stops that?
That requires an analysis of the law, and I can take my laws immediately.
Don't let me take you out of order. I mean, if it's law rather than a specific statutory provision,
It's
we'll
law.
be able to look at
It's
it
law.
later.
And I'm proposing to deal with it, but I may assist my Lords and my Lady if I just finish the tract
Yes, of course. Yeah.
with the supervision requirements. The next substantive hearing is on page 167.
Yeah. Now, this third period began on the 3rd of August. Does it have a termination date?
March 2009, my Lord.
Thank you. Right.
This is the hearing on page 167 on the 4th of June, so we're now some 6 months on from the last hearing and there's still been no contact. And if we look, Mr Keane is still there as a relevant person in consequence of Sheriff Tottenham's order. In the middle, Mr Keeney's solicitor, who's with him, explained his position. He finds it very difficult to accept the reasons given for non-contact, and the allegations were invention mainly of the mother, that's his position. And at the foot of the page, the panel decided to continue the supervision requirement with conditions of non-disclosure of address and non-contact with father. The reasons are there's no changes, no progress as to the veracity of the allegations. I assume that means the truthfulness or otherwise of the allegations, and the panel had no choice but to continue the condition of non-contact.
Well, how could there be progress?
Precisely.
Unless they let it go back to the sheriff, who could actually have a trial.
Exactly so.
Sorry, you call it a proof, don't you? But I mean,
Yes.
how can there be any progress?
Precisely so. Here is a tribunal who are there to have discussions. They're not there to establish facts. They can't establish facts. There's no prospect of proof. And they're keeping it away from the Sheriff Court.
And the only progress could have been if the mother had withdrawn the allegation, is that right?
All the social work department had managed to establish the veracity or otherwise of the allegation, and it's clear they're struggling about this.
Yes, it had been sent off. What were they? Were they looking into it? Were they?
Well, the matter had originally been continued for 6 weeks for an assessment, and it seemed to have been drifting on because nobody quite knows how to deal with it.
Well, the concentration seems to be on the position of the child, what the child was thinking about and so on, and the mother.
Yes.
But the other side seems not to have been considered at all.
Well, that's the concern of the father, of course, that his position wasn't being properly examined and that these allegations, which he was anxious to refute, were not being examined.
I'm sorry, Mrs. Scott, it's my ignorance, but what is the family support group, which is referred to, for example, on page 164 in the 4th paragraph of the order? It's also mentioned towards the bottom of that page.
I'm sorry, my Lord, 164.
164, fourth bit of the order, to allow the social worker to present the findings from the family support group.
I understand that to be a social work organisation, but I'm not sure what it was doing, and I can't assist further on
Yeah,
that.
I think it's the same referred to in the third last line of 164, whilst family support work is ongoing.
Yes. It's understood to be some sort of social work support provided to the mother and to the child.
Could I just be clear that the children's, I'm sorry, I've forgotten the name of the children's hearing, does it disavow any investigation of the allegations at all?
Well, it's not in a position to deal with allegations because all disputed facts should be dealt with when the grounds of referral are established
Right.
before the sheriff.
Right. But I just wonder why there is reference in the document in 167 to an assessment by the social worker that the allegations are true. And why do they receive evidence, or at least representations from the father, that they are not true? I mean, what's the relevance of that for the children's hearing?
The children's hearing are bound to consider all the information that comes to them, and they are bound to have a report from the social work department. That's part of the process of the children's hearing. And they're bound to discuss that with those present. And so they have the report says what it says about the child and the mother and so on. The father says, well, that's really just not true. But there's no evidence.
But do they make an assessment as to whether or not the allegations are more likely to be true, or do they simply say, well, that's not a matter for us, we can't investigate it?
They have to make an assessment of how best to proceed for the child, but they're not in a position to hear evidence. They're sitting around a table discussing what's to be done in the best interests of this child.
How do they do that if central to the question of the welfare of the child is whether these allegations can be substantiated?
That's one of the principal difficulties, perhaps, of the children's hearing system in Scotland.
On page 166, first paragraph, we see that there were child protection investigations going on relating to the father and his, what I take to be his other daughter, and another child at school. I mean, that's...
They were dropped.
No, those are, okay, yes. But was that, I mean, that seems to be featuring in this interim bit at the end of...
There was a realisation that what was being said in relation to this child could have an impact on his care of his elder daughter, and that's not part of my problem, or his problem in this case. That there were severe implications for his family life, for his reputation and his private life in what was happening here. And they couldn't properly be investigated. And the referral considered in relation to the elder child was, as I understand matters, dropped. It was not proceeded with.
Is that something which would be brought to the hearing by the reporter?
I don't think by the reporter. It would probably be the social work department or the father. The reporter doesn't really participate in the discussion at that point. Page 168, the father runs out of patience with this. Unsurprisingly, perhaps. 168, we're now at January 2009. There's still no resolution of this. And Mr. Keeney, at the foot of the decision, says the panel is now allowing his child to be abused at the current placement, is making a fuss of the judicial system. He runs out of patience altogether. And he appeals. He takes the matter to the sheriff and asks for a decision under Section 51 in relation to what's happening in the hearing.
Section 51.
That's the appeal provision.
Yes. This is where he got stuck because of the relevant
Yes, absolutely,
person.
and that's my stage 4. Because what happened when he appealed was the reporter effectively answered his appeal by saying, ha, you shouldn't have been a relevant person. The disputed order was incompetent, and asking the Court of Session to suspend it. And while the order was suspended, of course, the man was excluded from the children's hearing, effectively. I understand there was one invitation issued to him which he says he didn't receive. So he tries to go back to the Sheriff Court. and we have a revival of the action in the Sheriff Court. But before I get to that, perhaps I should answer my Lord in the Chair's question about why is it that the Sheriff Court action is in difficulties. And if I can do that by reference to 3 cases, one of which is a very familiar old Scottish authority, which is Aitken against Aitken at tab 3.
Not familiar to me, but
I'm so sorry.
Which tab are we in?
It's tab 3.
Tab 3.
I'm sorry, one gets rather immersed in these things.
yes, well, I think we can assume a degree of ignorance over in this member here.
On this
I'm
wing,
sure not.
a fortiori here.
Aitken was the case that determined the relationship between court orders and supervision requirements. And in Aitken, what had happened was the Court of Session pronounced an order which gave custody, as it was in those old days, to the father in relation to 2 children in a family. And the children were referred to the children's hearing, and the children's hearing made a supervision requirement with a requirement that these children reside with mother, and the local authority didn't know what to do. So the matter was referred to the First Division. And the upshot of that was that the division explained, and perhaps I can best do it by reference to their last paragraph on page 303 of the report.
So this is Lord President Emsley at 303.
Yes, yes, indeed. I think it probably is encapsulated in that last paragraph. The effect of the law ordinance interlocutor, his order of the 3rd of February, was to invest the defender father with the right of custody of the children and empower him to exercise that right, including the right to care for the children, so long as the exercise of that right was not rendered impossible during the currency of any lawful order affecting the children. The supervision provision made in that interlocutor was designed to, this is supervision in relation to the court order, only to the situation where there was no lawful obstacle to the exercise of the defender's right of custody. The effect of the supervision requirement made by the hearing was to create just such a lawful obstacle to the exercise of the defender's right. And by placing the children in the care of the regional council, the children's hearing have made it impossible for the defender, so long as the requirement survives, to exercise his right of custody by having the children living with him. The obligation of the regional council under the order, the court's order, is accordingly in abeyance until such time as the supervision requirement of the children's hearing is discharged. In the meantime, their duty, in terms of the old Social Work Scotland Act, is clear. They must give effect to the supervision requirement made by the children's hearing while it subsists. And so the regional council were obliged to place the children with their mother because that's what the children's hearing said. So what this means is that so long as you have a supervision requirement, any condition in that requirement prevails over any other court order.
No matter how high the level at which the court order was made.
Precisely so, precisely so. And it was, of course, a competition between not a sheriff's order, but a Court of Session order. And that's logical, because these are supposed to be child protection measures.
Yeah.
But is it logical that it can have a freestanding existence? Surely, in the real world, a supervision order has to be attached to a contact order.
Well, we're talking about a different thing here, my lord. We're talking about a Scottish children's hearing making a supervision requirement, and the terminology is perhaps confusion. But a supervision requirement is a child protection measure to which conditions may not be attached.
But it also includes the possibility of the child being removed from home indefinitely.
Absolutely. Well,
So the word supervision is
yes. Although indefinitely one has to qualify, because of course it can only be in short snapshots.
it goes, yes, but indefinitely.
In
Because,
effect, indefinitely.
yes,
Yes, and
Yeah.
the same with contact.
yes.
well, you just help me with that. Where's supervision or requirements? Where do we find those?
Section 70 of the Children's Scotland Act law, page tab 10.
Section 70.
Yes,
It-
in current law.
It includes residence in secure accommodation.
Absolutely, yes, quite so.
Locking the
They're-
child up.
Yes. Right from just having the social worker visit once a week or less than that
Yeah.
to secure accommodation or placement with foster parents with a view to adoption. The whole gamut.
Can you help me to cross-refer from section 44.5 of the 1968 Act to the provision in the 1995 Act?
Section 44 was the old supervision requirement condition, and its equivalent is now in Section 70.
Right, I see. Okay.
And Section 70 is the provision that says where the children's hearing to whom a child's case has been referred are satisfied that compulsory measures for supervision are necessary in respect to the child, they may make a requirement under this section to be known as a supervision requirement. A children's hearing where they decide to make such a requirement shall consider whether to impose any conditions such as is described in subsection 5b below, and that's in relation to examination or treatment or regulating contact. And then subsection 3, a supervision requirement may require the child to reside at any place or places specified in the requirement and to comply with any condition contained in the requirement.
It's the bit which says it shall be the duty was what was in the. That was what they were referring to. It shall be the duty of the local authority to give effect to a supervision requirement. That was what they were.
Precisely.
And is that reproduced here?
Yes, it is. That's in section 71.
71?
Yes.
Oh, yes. So it's really 71.1 is the corresponding provision to 44.5, is it?
That may be correct. I'm sorry, my Lord. Yes. The Children's Hearing Scotland Act expanded on the old Social Work Scotland Act.
Yeah.
I think most judges in England sitting in family courts would like the equivalent of Section 71.
Yes, well, we've had trouble making sure that local authorities do this, and we've enacted some rather more severe provisions on local authorities. So it's not as wonderful as my lady might quite hope.
Right. Thank you.
So the First Division in that case decided that Section 71, the equivalent of 71.1 rules, yes. And you've for the local authority, that's what they have to do.
Yes, indeed. And generally, the decision has been taken to mean that the measures imposed by the Children's Hearing supersede to trump, if one likes, any court orders.
And is there anything? I mean, there's nothing which actually says that.
No.
So the only people who are given this specific obligation to follow the to give effect to the requirement of the thing are the local authorities. Is that right?
On the other hand,
or is that not? I mean, I'm just asking.
A parent couldn't exercise their responsibilities and rights in contradiction of a supervision requirement, and that's in Section 3 of the Children's Scotland Act.
Yes. Yeah.
That's Section 3, subsection 4.
Yes. Yes. Yes.
The general position is once the hearing has pronounced, that holds good for so long as there is a supervision requirement. Now, the question which then arose for the courts was what happened about contact orders, and could the courts then make contact orders? And initially it was thought that the court couldn't make a contact order when there was a supervision requirement. That was re-examined in relation to the Children's Scotland Act specifically in a case called P against P, which is at tab 38.
Did you say that it was initially thought that the court could or couldn't make a couldn't?
That is a position which is now superseded by P against P, which is the case I need to refer my lords and my lady to. What happened in P against P was a child was living with her grandmother, subject to a supervision requirement. And it was thought that the requirement could be brought to an end, that Granny had no responsibilities or rights. In addition, Father wanted a contact order. And Grandmother applied to the sheriff for a residence order, and father applied to the sheriff for a contact order. And the case came out before Sheriff Mitchell in Glasgow, who said, I can't make either of these orders because there's a supervision requirement. And that was then taken to the Inner House on appeal. And what the Inner House said, putting it in a nutshell, was, of course it's competent for the court to make orders, but it's not always appropriate for the court to make orders. If I could, on the basis of that explanation, take my Lords and my Lady to page 786. The extra division deals first of all with the grandmother's application for a residence order. And the factual circumstances were examined, and we see from J on page 786 that the division are informed that the local authority are well disposed to an application with a view to seeking in due course termination of the supervision requirement. So we're looking
Well, there wouldn't be anything inconsistent with Granny having a residence order and the supervision requirement requiring that the child live with her.
Absolutely.
Seems quite
Yes,
logical.
absolutely. Well, this is what the division held, and we're of course overturning the sheriff. But what they said was, and they looked back at my Lord and the Chair's decision in F against F, which was the grandmother's case in conflict with the freeing order, and letter E, they noted that when my Lord and the Chair was Lord President, he expressed the opinion it would seldom be appropriate for an order of custody to be pronounced in favour of persons who couldn't in practice exercise those rights for the time being, but didn't suggest it was incompetent to do so. Accordingly, we don't suggest the sheriff was entitled to deduce from Aitken justification for holding the pursuer's application was incompetent, and in particular to dismiss the action and thus refuse to make the order sought without further inquiry into the circumstances. He was bound to consider whether the making of the order sought was appropriate or not in the whole circumstances which he held to be relevant, and looking to the provisions of section 11.7 in particular, whether to make the order sought or not. So far so good in relation to that. The court then turned to father's application to the court for a contact order and examined that. And on page 788, at letter F, we come to the parts of the decision which are crucial for this case. The division said this: we find no difficulty with the proposition that where a supervision requirement incorporates a requirement upon a child preventing or limiting contact between the child and another person, any order applied for from the court which sought in effect to vary or discharge that additional requirement would be inappropriate, and in that respect could be said to be incompetent, but that's not said to be the position here. And then the division goes on that they look at Wilkinson and Norrie, a standard textbook on parent and child, and just below letter I, they quote from Wilkinson and Norrie, thus to make a contact order in respect of a child who is subject to a supervision requirement does not qualify the local authority's responsibility and right to control who has contact with the child. It inhibits the children's hearing's decision-making powers to no greater extent than a residence order, which unquestionably can be made during the subsistence of a supervision requirement. A contact order is not, therefore, necessarily inconsistent with the supervision requirement. It follows, it's submitted, there's nothing to prevent the court making a contact order under section 11.2d during the subsistence of a supervision requirement. Of course, if the terms of the order are inconsistent with the supervision requirement, then the former is suspended until the latter is varied or terminated. It remains open to a children's hearing to make contact arrangements different from those in a pre-existing court order, in which case the terms of the supervision requirements are again given precedence. And the division says, we would generally agree with that statement, subject only to this qualification, that we would regard it as inappropriate unless the circumstances were exceptional, and justified the court in doing so on a proper application of the three overarching principles to grant such an order which would at the time of its making be inconsistent with the condition attached to a subsisting supervision requirement. And then on the following page, just letter B, they say, just taking it below letter B, in the end of the day, however, it'll be for the court exercising its discretion in terms of 11.7 of the Act, with the knowledge of the existence and terms of the supervision requirement, to determine in the light of the whole circumstances, including any court orders which it may decide to make or not, whether such a contact order should be made or not. Thus, at this stage, we do no more than note the making of such an order may hinge upon the sheriff's decision with regard to the orders sought by the grandmother, not least because something may depend upon the attitude of the local authority to an early discharge of the current supervision order. So, the decision of the division is it all depends on the circumstances.
Do you agree with this?
Well, Well, given that the orders in relation to children are designed to operate at the time that they're made, and you don't make an order now for something that might happen in a year's time, then there's obvious sense in this, that it would be inappropriate to ask the sheriff to make a contact order now, which couldn't be exercised because the children's hearing had control. And if one wants to have a logical and consistent legal system, one shouldn't be setting up a situation where one has competing requirements. And that seems to me the sense of what the division are saying. They're saying if the children's hearing's got control of it, and are not likely to relinquish it in the immediate future, then the children's hearing should retain control, and it wouldn't be appropriate for the court to intervene. And they go a little further than that. They say, in that sense, it would not be competent for the court to intervene.
But there's a difference, isn't there, between the children's hearing having control in the sense that they are continuing to hear the case and there is a supervision requirement, and what the children's hearing put into the supervision requirement, which may or may not be inconsistent with the court order.
Precisely.
They're not saying that they can't make an order.
Absolutely.
They're saying don't make an order that's inconsistent with the actual requirements in the supervision requirement.
Yes, I don't do it. And of course, what we have in this particular case is the children's hearing saying no contact. And so we're in precisely the circumstances where the division are saying, well, it's not going to be appropriate for the court to roll up its sleeves and make a contact order. It would be inappropriate and, in that sense, incompetent for the court to make a contact order.
You're in no position, standing the decision below, to appeal
To appeal the...
the supervision.
Well, that's of course what he tried to do.
Yes, I know, but standing the decision,
Yes.
you are not in a position to appeal. Is that right?
Precisely, yes. I'm stuck.
And you can't get back to the sheriff's court in order to have an investigation because of the existence of the supervision order.
Well, that seems to me to be the position. That's the conundrum that we're in at the moment. I should perhaps conclude this by saying there's been a very recent examination of this by an extra division in Authority Reporter against S. And it's a decision which has been given since the decision in the present case. And we should perhaps just look at that. And that's at tab 5.
In volume 1. In volume 1. In tab 5 in volume 1.
Tab 5 in volume 1.
I confess I haven't come across the Authority Reporter before. What is that? Or who
It
is
seems
that?
inconsistent with the statute as well, where the all actions are supposed to be taken in the name of the principal reporter. But there it is. This were two cases considered together by the extra division, and they both involved fathers who had standing a contact order before their children were referred to the children's hearing. I think my own friend Miss Wise appeared for the reporter in that case as well, and she'll be able to assist the court further with it. And the issue was, standing that they had a contact order, was there an inconsistency in not allowing them to be in the children's hearing? And the extra division finally read down the provisions that we've been looking at in section 93(2)b. And perhaps the relevant part of this should be taken from, no, for the present purpose, from 777, page 777, just below letter D. And this is the extra division looking practically at what the position of a father would be. And they say at letter D further, as to the position after a children's hearing has made a supervision requirement preventing contact with an unmarried father, the right then to obtain parental rights and responsibilities is likely to be entirely illusory. It would be extremely difficult in practice, in the absence of information as to grounds of referral and so on, for an unmarried father in the position of the two fathers in that case to persuade a sheriff to grant such an order. And the sheriff in the case of S, while apparently sympathetic, was not so persuaded, and that was an order relating to parental responsibilities and rights, not contact. In the same way, if an unmarried father had no contact before a supervision requirement of the type in question was made, the chances of him obtaining such a contact order from the court thereafter, so long as the supervision requirement remained, would have to be regarded as negligible. As was said in P against P, and there's a quote from the passage just read. And then, although in principle reporter against K, that's our case, it was said, the correct interpretation of P against P is simply that a contact order may be inappropriate where it conflicts with the supervision requirements. Thus, in the normal case, a court should not grant such an order, but it's not incompetent to do so. And there may be situations where such an order will meet the criteria of the overarching principles. For example, it may be known that a supervision requirement or condition of it will shortly expire, and the court may consider it appropriate to regulate matters in anticipation of the expiry date. This, it may be said, opens only a very small window of opportunity. So the extra division are recognising the hopelessness of a father in the position of the present appellant.
So what did they do in the end?
They read down the requirements, section 93 2b, and one sees that at 778 at letter H. They read it as any parent enjoying a parental responsibilities or rights, or parental responsibilities or parental rights, or a right of contact in terms of a contact order under Part 1 is a relevant person.
Not difficult, as parental responsibilities or rights include contact.
Well, the argument there, and again the learned premise wise will be able to assist the court, was that a contact order is an order about practical arrangements. It's not an order about responsibilities or rights, and that was held to be correct by the extra division. So a contact order is not a parental responsibilities or
Where
rights
did they
order.
hold that? Sorry, where was that held?
That's in the domestic argument.
But you can say it's the arrangements for implementing one of the principal responsibilities, isn't it?
We've had a long debate about this, and it seems to have been determined by the division that a contact order is not an order in terms of 93(2)b. It's an order relating to parental responsibilities and rights, but not conferring responsibilities and rights. It's a narrow decision, but they ended up reading down the terms of section 93(2)b.
Whereas if they've said what I've just said, they wouldn't have had to read down at all.
But precisely. But again, Miss Wise will be able to assist the court because she argued this case.
So they were referring to the definition, presumably, is that
Yes,
right?
yes. I think that it was referred to, what the fathers had in this case was referred to as a bare contact order, as opposed to an order conferring the responsibility and right of contact.
They pose the question at paragraph 47,
Yes.
I think, is where it all begins, doesn't it? This is page 775.
Yes. And this is the ECHR argument as opposed to the domestic argument. They divided the matter into domestic and ECHR. I think that paragraph 46, it's accepted, certainly by the sheriffs, that a contact order wouldn't vest parental responsibilities or parental rights in a person in whose favour the order was made. And then at the foot of the page, we're inclined to agree with senior counsel for the reporters, that's my learned friend Miss Wise, that a person could only be said to be enjoying a right if he had that right by operation of law or by an order of court. And the real distinction between relevant persons was not so much between the words enjoying and vest as between any parent and any person. It was a very technical argument on the precise terminology of the section. Of course, the interesting thing about the authority reporter against S, if one measures this case against that, is that the appellant in this case would have popped in and out of being a relevant person depending upon whether or not he had an interim contact order at any particular moment. It doesn't really help him a great deal.
he would at one time have had one, is that right? He would have one time have been a relevant person.
If this decision had been known and in force and this reading had been in place, he would at one time have had one. But then the sheriff suspended the order to make investigations and he would have ceased to have been. And then the sheriff reinstated it and he would have been. And then the sheriff took it away to make more investigations. And I think there were 3 periods when he had a contact order, when he could have been a relevant person, and periods between when he wouldn't have been. Now that takes me to the 4th period, the 4th stage of the action, which is March 2009 to date, when there's been no right to appear in the children's hearing, but we have had a revival of the Sheriff Court action. And I don't want to take my lords and my lady through the process. There have been numerous hearings, a fixing of a proof, which was initially going to be 5 days in February, and then 9 or 10 days, 2 weeks, and was finally discharged. And one can understand in my submission why it was discharged, because the sheriff simply didn't know what to do with it. If the disputed order remains, then there's no need for it, because the man can go back to the children's hearing. Or if my lords read down the legislation, he can go back to the children's hearing. So the point of having 3 parties representing sort of 30 council days in the Sheriff Court proof seems a little bit...
And was this so that the sheriff could decide whether or not, in the light of the overarching principles, an order should be made? Giving...
It wasn't clear what
what was it for? What were these 9 days for?
Precisely. It was completely unclear what these 9 days were for.
So where do we see this order?
Is this page 135? That's the interlocutor we're talking about.
Yes, that's the interlocutor of the discharge, yes.
But it doesn't tell us much about
No,
what
it
the proof is
doesn't.
going
It
to be.
doesn't. But my understanding is that the sheriff on that date felt she couldn't proceed because she didn't know what this was about. And the original sheriff who set this up, Sheriff Platt, seems to have thought he could have had a general proof about the allegations, but of course that wouldn't have got one anywhere because he couldn't make a contact order on the basis of P against P. He probably couldn't have made a parental responsibilities and rights order standing the position. And the most really that Mr. Keeney could have got out of it would have been an order to allow him to go back to the children's hearing, which is the matter before this court for appeal in any event. Of course, if the original sheriff was right, this was a matter that could have been dealt with, and this is my next argument. Very simple, to child welfare hearing.
Sorry, I missed the last bit.
Yeah, if the original sheriff was right, this should all have been dealt with very simply at a child welfare hearing. You wouldn't have needed a 10-day proof with 3 parties present represented. Now, my apologies that preamble was so long, but that takes me to my first proposition.
Yes.
Which is the proposition that the Court of Session has erred in holding that the disputed order was not competently granted.
Sorry, where was it? Can you just... When was the actual original order made for this now non-existent proof? I mean, it seems to go way, way back, and I haven't found where it is.
It meandered its way on
Yeah, I've got
on page 122.
122, is it?
Yes. What happened was, as rather a belt and braces exercise, the appellant's agent went back to the sheriff and said, if there's a dispute about this original order for parental responsibilities and rights, please give me another one. That came before the sheriff in August of 2009. The sheriff said, I can't do that. But what we'll do is we'll set up a proof. And this is Sheriff Totten again on the 27th of August.
So he must have thought that there were going to be pleadings. He thought he had pleadings, so he must have known what he was...
No, exactly so.
Do we have these pleadings or we not?
No, we don't, no. The pleadings, I don't think, are in the form... I think the pleadings in the original form are in the appendix, but not the pleadings as they developed. There are a set of pleadings, but not the final form of pleadings in the matter. Page 73.
Page 73.
73. These were the original craves and pleadings think prior to the Sheriff's order in August.
Well, certainly plenty of pleadings anyway, so...
There are plenty of pleadings, yes, but the problem is what they're relevant to. I think the Sheriff, finally faced with the 10-day proof, thought, well, what am I actually going to have to decide here and on what basis? And it wasn't at all clear.
According to the index at the beginning of this bundle, these are the pleadings as at July 2007.
Yes.
And one understands they may have been amended since.
Precisely, yes, they have been, yes.
Well, you were coming to a submission.
And this is my first proposition. What I understand I'm required to address is the ratio of the decision of the First Division at paragraph 67 of their decision on page 19 in the core volume. At the top of page 19, the Sheriff in this case clearly appreciated he could not simply grant an order making the father a relevant person, and this is back to the October 2006 order. He had in mind he would have to impose upon him a parental responsibility or give him a parental right, hence the structure of the interlocutor, but it's apparent from the submissions made concerning the child welfare hearing on the 27th of October 2006, the Sheriff nevertheless restricted himself to the limited question of whether the father's appearance at the children's hearing would be of assistance to that hearing in determining the appropriate order to make, and would thus contribute beneficially to the child's welfare. No party suggested that at the child welfare hearing the Sheriff had addressed or even been invited to address the three overarching principles. It was not maintained by any party that what occurred was the Sheriff had reached the view the father was meritorious in terms of McMichael. In failing to reform a view by applying the overarching principles, the Sheriff erred in law. He acted otherwise than within the powers conferred by the Act, and thus in an incompetent manner. Now,
I understand the curator disputes that as a matter of fact.
Yes. And I have to say my recollection was that this was not a matter discussed.
But even if, let's assume that nobody's in a position to say what actually was said at the hearing. Yes. Speaking for myself, I find it very difficult to believe that a sheriff who was making this order, familiar, as one assumes, with the Act, would ignore the basis on which you make these orders, as set out in subsection 7. Unless one has some indication to the contrary. I would have thought one would assume in the Sheriff's favour that the order was made against the background of what he understood it was open to him to do.
Yes, one hardly needs the Latin omnia rita essay.
Yeah.
Well, especially as you pointed out that Sheriff Totten was a designated sheriff. And I mean, one has the impression, and this may be entirely wrong, that Section 11, subsection 7, overarching requirements provide the perennial backdrop to this type of application.
Precisely. And of course, it's a child welfare hearing that he's sitting in.
I mean, it's just daily routine for
well, it
sheriffs
is
dealing
precisely
with these
so,
cases.
precisely. It's inconceivable in that situation that he would not have had welfare in mind.
But there isn't any contrary evidence, is there? I mean, there's nothing, he hasn't said anything which indicates that he had his mind on something totally different. And
Absolutely.
nobody present has come up with any suggestion he was thinking of something totally different.
Do I understand suggested that this wasn't actually argued to the inner house, or am I wrong on that?
My recollection is that it wasn't argued. I know that my friend for the mother considers it was, but it's not in her note of argument, and it's not in the way the division have noted her arguing it. I don't have a recollection, but she will obviously have a recollection for the court.
But I think your position in your case is that this wasn't an issue that loomed large on the hearing.
No, not at all. The issue which was argued by the counsel who then appeared for the reporter, it wasn't one premise wise, was that there was a defect in the form of the interlocutor. And that doesn't appear to have troubled the division, because if one looks at what the divisions say, well, it doesn't matter if it looks like a final interlocutor. We know it's happened in the middle of the case, and in any event, of course, in children's cases, this is me expanding on the division, no interlocutor is ever final, but that doesn't seem to trouble them. They were concerned that the interlocutor didn't identify which specific responsibilities and rights were there, but that doesn't seem to be the ground for lack of competency. And indeed, in my submission, it couldn't be if you look at the terms of section 1 and 2, where parental responsibilities has a composite meaning and parental rights has a composite meaning. And they don't seem to have been troubled by the thought that there was a restriction on the exercise, the circumstances of the exercise either. So this was the focus of the problem for the First Division.
Scott, I'm just wondering why they prima facie, it's a strange thing to say, but here, of course, we're not dealing with an appeal, are we? So they couldn't touch that order unless they said it was an incompetent order.
Precisely.
Mm-hmm.
So that's why they had to say it was incompetent.
Yes.
But the question really, I mean, I can see that they might take the view that it was wrong or something like that, but the question is, was it a competent order to make? And I get the impression from paragraph 68 saying that they could have made this order if the sheriff could have made this order if the sheriff had gone through the hoops of the overarching principles.
That's how I read the division's decision. Yes, and I don't.
So there was nothing incompetent in the order. It may just have been that the sheriff didn't do what he was meant to do, in which case you'd have expected the parties to appeal that order, and if so, have it set aside, and so on and so forth. But it doesn't make the order incompetent, as I would see it.
I'm grateful to you.
Is there a point arising under paragraph 68? You see in the sentence about halfway through, the court ought to specify which of the defined parental responsibilities and or rights it is imposing. Now, if you go back to subsection 2, the structure of the subsection, of course, in section 11 it does set out a list of particular orders that might be made, but have they overlooked the opening words and the fact that it is open to the sheriff under subsection 2 to make an order which isn't in the terms specially listed, but nevertheless is appropriate for what he thinks is required to be done?
Absolutely. Yes, the sheriff is, as one would expect in a piece of legislation dealing with the welfare of children, the sheriff is given complete flexibility to do what the welfare of the child requires. And in my submission, he's done it.
Was it argued that this was incompetent in the sense that it was an order which the sheriff had no power to make, rather than that it was simply a wrong exercise of the power?
Yes.
That was argued.
My understanding of the argument was that the sheriff couldn't make somebody a relevant person.
Yeah.
Yes.
And the distinction that was being drawn was between an incompetent order that says, this is a relevant person, and an order which said, this person has parental responsibilities and rights and thereby becomes a relevant person. And the reporter was seeking to argue that the order was incompetent in the first sense, and my argument was, no, this is an order relating to parental responsibilities and rights, and therefore had the effect that he was a relevant person.
Do we have the petition?
Yes, we do.
Because I see that they granted declaratory in terms of the prayer.
Yes. The petition is at page 48.
Sorry, where?
Sorry, page starts at 42. Yes. And then the statement for the principal reporter on page 49, statement 6.
Sorry, which page are we looking at?
Page 49, I apologise, 49, statement 6. where the principal reporter complains that the sheriff does not have the power under Section 11 to pronounce an order declaring that the person is a relevant person in the children's referral. Under Section 93 of the 1995 Act, a relevant person is either a parent enjoying parental responsibilities or parental rights, or any person whose parental responsibilities or rights are vested, and so on.
So the whole issue was that it was an incompetent order that the sheriff had made.
Yes, yes. And the division appeared to have rejected that argument and said, no, this is an order relating to parental responsibilities and rights, but for a quite different reason to that advanced by the principal reporter. We find it to be incompetent.
So you say the effect of the judgment is that if the sheriff had, without being pejorative, repeated the mantra, I am applying the overarching principles here, and I am, on that basis, making an order confined to making the father a relevant person, that would have withstood scrutiny.
Provided it was an order relating to parental responsibilities and rights, it should have withstood scrutiny.
Was the original order, I'm getting lost, was it in proceedings to which the reporter was party?
No, not at all. This is the reporter coming in and asking the Court of Session to suspend an order in private law proceedings between parents involving curator ad litem for a child who was perfectly satisfied with the order and suspending it.
What about the third plea in law at page 57? That focuses Lord Rogers' point, I think. The plea, it was stated that the petitioner had no title and interest to seek suspension. What did
that was for the respondent.
What happened to that in the Outer House?
Well, that was these answers were put in after Lady Stacey had made her decision because the matter was brought up in the vacation court.
Yes, I follow.
And the answers were subsequently presented. A decision was taken that this was going to have to be determined at some point, and given we were before the Inner House, it was better to have the argument there and then than to have it come back in some other guise at a later date.
So the plea wasn't insisted in?
No, it was not insisted.
Right. I'm sorry, forgive me again. If the sheriff had then said, I've had regard to the overarching principles, I apply those, I make a parental responsibilities order, but this will be confined in effect to making the father a relevant person, that would have satisfied all the requirements, would it?
I think there might have still been some parsing of that, and I think there might have been an argument that he couldn't say that. My argument would be that that would be properly seen as an order limiting the exercise of the responsibilities and rights of the children's hearing. And in my submission, that would have been perfectly in order.
I think it is clear that that position would have been taken, the position just indicated would have been taken, or was being taken, by the reporter, because if you look at page 50, in the middle of the page, what's said is participation at a hearing is not a parental responsibility or right in itself.
Mm-hmm. Yes.
So
yes.
that was their position.
Yes. Their position is that if you have parental responsibilities or rights, that entitles you to attend, but attendance is being a relevant person is a byproduct, yes. It's not an end in itself.
Yes.
So when the division say a court ought to specify which of the defined parental responsibilities and or rights it is imposing, do they say it could have been done here? Just as it says it wasn't done.
They didn't determine that the order was incompetent for that reason, because the nub appears to be in section 67. But they seem to have been saying that you have to go through sections 1 and 2 and say which of the responsibilities and rights you are looking for. But in my submission, that cannot be correct. It's perfectly competent to order parental responsibilities and to order parental rights generically and say, I'm putting this person in the same position as a married father, given the definitions in section 1 and section 2 and the way that section 11 is framed.
Well, it strikes me that section 11.2a is an invitation to be selective if you want to be.
Yes, precisely.
No, of course, we're not dealing with a 2a case. But I mean, if you want to limit the responsibilities or rights, then the sheriff has that opportunity to do so under A if he proceeds under that heading. But I was suggesting too that the problem really is that they haven't looked at the opening words and the even wider scope that's given under subsection 2 before you get to the list.
So the whole framing of the Act in terms of Section 1, Section 2 and Section 11
Yes.
make it perfectly competent to give a whole range of parental responsibilities and parental rights. But then, if one is looking at...
Sorry, where does the bit which allows them to impose a selection of these rights?
I think it's the reading that one might give to Section 11.
I mean, I see you can remove some of them.
It's Section 11.2b
I'm seeing that.
is imposing upon a person such responsibilities and giving a person such rights.
Yes, I'm just drawing attention. I mean, I just noticed that the A, which deals with deprivation, talks about some or all of his parental
Yes.
responsibility, parental rights. B doesn't seem to make that particular distinction.
My Lords,
Unless such encompasses
Yeah, well,
that phrase.
yeah, exactly. Maybe so.
My Lords, given that this is a statute relating to children and the benefits to children, I would submit it has to be given the widest possible interpretation, and the Sheriff has to have the widest possible powers to do what's right for the child.
Maybe right. It may very well be right. I mean, because it would be strange if it were appropriate to grant some right, but not all, that you couldn't actually do it. It would be very strange. When Parliament has recognised you can take some of them away and leave some, so it would be very
The
odd.
criticism seems to be that he didn't say full or all, but in my submission, once he's said parental responsibilities, you assume it means the parental responsibilities defined in Section 1, and once he said parental rights, he means the rights defined in Section 2.
Well, which ones? I mean, supposing he had asked, what would he be asking for? I mean, supposing the sheriff had done what the division were thinking, specifying, what might he have done?
Well,
So
if I'd
living
been-
with him to maintain personal relations and direct contact with the child or something like that.
If I had
But
been
therefore,
asked to address that, what I would have said, and I think I did say to the division, was that overall this man wants the responsibility to safeguard and promote his child's health, development and welfare, directly.
That's
Second,
1A.
yes. A second, he wants indirectly to provide direction and guidance to his child. And third, he would like the responsibility to maintain contact with his child. And then in terms of rights, the rights that he would be looking for specifically are to control, direct or guide the development of the child's upbringing and the right to maintain personal relations and direct contact.
but they couldn't have given them right of contact, could they? If given standing the thing. I mean, that's, I presume, why actually the sheriff limited it in the way he did.
Yes. What he did was he said, I'll put you in the same position as a married father, but only as far as the children's hearing goes.
This is what troubles me. I mean, if the sheriff had said, well, my objective here is to get you access to the children's hearing, I have to go through, again, not pejoratively, the hoops that Section 11 imposes on me, and therefore I'm going to say that this, I have had regard to the overarching principles, and I'm going to make an order, but the objective of this order is confined to making sure that you get to their children's hearing. Would that have been a valid order?
One would have to, I don't think one could put the objective into the order. I think one would have to say, I give you parental responsibilities and rights, but restrict their exercise. And in my submission, that's what he's done.
And it's legitimate to restrict the order to simply means of getting to the children's hearing.
Well, restrict the order so that it can only be exercised at the children's hearing. For example, if one had an unmarried father who wants to take his child on holiday, and he doesn't have responsibilities and rights, and the court has not yet determined whether he should have responsibilities and rights, but would like to make an order in the benefit of the child that the child goes on holiday with the father. And I've done this as a sheriff. One says, right, have responsibilities and rights for the period of that holiday to make sure your child's all right on that holiday. And you then restrict the operation of responsibilities and rights to the period of necessity. Now, if one goes back to the children's hearing, one might be saying, well, have responsibilities and rights, but exercise them in the context of that hearing, not outside the hearing door, but within the hearing.
Could one express what you've just been saying by looking at section 11, subsection 1, because that is the, it might be thought to be the overriding power, because it says an order may be made under this subsection in relation to, and then there's a list of these things.
Yes.
And then you've got subsection 2, of course, saying an order under subsection 1 may be such order as it thinks fit.
Yes.
Now, you could say, well, having regard to, and then you could list the parental responsibilities that you mentioned earlier and the rights and so on. Having regard to those, the applicant or whoever he is entitled to exercise those rights at the children's hearing.
One could.
So you would build it in that way back to section 1 and subsection 2 by a narrative form, which isn't in the interlocutor, but one might think could
The
have
Lord
been
will
there.
seen the interlocutors granted in this case. They're typical. A sheriff in Glasgow Sheriff Court will have a long list of child welfare hearings and makes interlocutors in their operative part. It doesn't tend to build in a long preamble as to why and so on and so forth. These things are not normally contentious.
Supposing that the sheriff had said, I'm just looking at, just thinking out loud, of course, but section 1(1)(c) it said there is further responsibility to maintain personal relations, collect contact with the child on a regular, subject always to the requirements of the supervision requirements or whatever it be.
That would be automatic in terms of section 3,
Yeah,
4
but,
in any
just,
event.
but yes, I know it would, but just making clear that it was really always subject to this.
Yes.
It's belt and braces, but it wouldn't make a difference.
No. It was certainly possible to construct an order, but in my submission, the sheriff has done a perfectly good job in constructing an order. And I understand that many of these orders were issued at about that time in Glasgow Sheriff Court.
I'm sorry, say that again,
I
please.
understand that many of the similar orders were issued at about that time in Glasgow Sheriff Court. This was the standard form of order. And there were, I think,
I want to be quite clear about that. What we see at page 108 then is something that you quite frequently encountered.
As I am informed, that these orders were fairly regularly encountered. And there were, I think, 8 petitions for suspension of them. All by the reporter.
Yes.
Now, if I might add just very briefly to this chapter a number of headings without necessarily elaborating unless it was assist the court. The sheriff had the benefit of a curator ad litem who supported the order. She was there to safeguard and promote the interests of the child. And I've given reference in the bundle to the standard authority of Drummond's trustees against Peel's trustees, which is a very long 13-judge decision, but the relevant part is Lord Hunter's opinion at page 504, where he says, well, a curator's there to safeguard and promote the interests of the child, which is trite. Second, the sheriff, of course, on that date continued uncontentiously a contact order. And so it was a matter as uncontentious that contact at that time was in the interests of the child, and which gives a further clue as to why it was in the interests of the child the father should be at the children's hearing. Third, I pray and aid the decision of the First Division when Lord Roger was Lord President in White against White, which was a decision about contact, but discussed the issue of a working hypothesis that contact between fathers and children was acceptable if one's looking at decisions that are made day to day in the Sheriff Court, and I would submit that there's a similar acceptable working hypothesis in relation to the presence of fathers at children's hearings. Does anyone wish to look at White? It's tab 55.
you asking us to look at that case?
Well, only if my Lord wishes to look at it. Just briefly, this was a case where the sheriff had given a father contact. It was a married father. The sheriff principal had overturned the sheriff on the basis that the father had failed to satisfy an onus of proof, and the First Division reversed that. And the passages which may be of assistance to the court are on paragraphs 14 and 15 of the decision at page 695 and 696. Discusses the welfare test. At letter E, in other words, when Parliament says judges to have regard to the welfare of the child, it must consider that judges will, and by and large, have a common conception of what that involves or will advance the welfare of children in regard to matters. More particularly, Parliament must consider they will have a common conception of what will, generally speaking, be the interests of children as far as contact with their parents is concerned. If it were not so, either the test would be meaningless, or else a court could never apply it without expert evidence, which might vary from case to case as to what would, in general, best serve the interests of children, and therefore the child or children in question. But of course the test has to be applied daily in courts up and down the land, not only after proof, but much more often in relation to motions for interim orders, and so on. And then on the following page, there's a reference to my Lord in the Chair's decision in Sanderson against McManus in relation to contact, and a reference to a working hypothesis born of human experience. And further down the page at D, the power of a particular assumption that it would be in the interests of children to see their fathers can perhaps be gauged by imagining the outcry if a judge were to declare that she would take as her starting point the opposite assumption, that normally a child would not benefit from contact with his absent parent.
I wonder why my Lord assumed that the judge in that case would be a woman rather than a man.
I can't remember, to be honest.
I think all the judges concerned in that case had been gentlemen, so it was simply an application of equality, as one would expect.
Or something.
But I draw on it simply to say that these are matters of common sense, and working hypotheses and so on. So of course the sheriff thought that it was appropriate that this man should be at the children's hearing. It almost goes without saying.
And the irony, of course, as you pointed out already, this sheriff's interlocutor subject, now that we've got the decision in whatever it's called, S, the first part was unnecessary, given that he was applying, he's giving contact.
Yes, but of course, shortly thereafter the man ceased to be, and then he came again, and so on and so forth. So it doesn't solve the problem for me.
No.
Yeah, the other matter I was going to refer to was Kilbrandon itself, which is at tab 80, and there are some additional pages.
Where is that?
In tab 80 in the final volume, and there are additional pages that my Lords have been given on that.
Which page are we looking at?
Probably best to start on page 12, just to give a preamble to those who... I appreciate my Lord and the Chair and my Lord Roger are very familiar with this, because Kilbrandon was the commission set up to examine juvenile justice in Scotland, which resulted in the children's hearing being established. He reported in 1964, we had the Social Work Scotland Act of 1968, and that's now carried forward into the current legislation. But central to the thesis of Kilbrandon was that children who are juvenile delinquents or offend are the same children who may be in need of care and protection, and that one shouldn't discriminate between the two. And that starts to appear in my submission in paragraph 13, and continues on the following page to paragraph 15, when the Commission establishes that what we need here are special measures of education, because the normal upbringing processes have, for whatever reason, fallen short. And then in paragraph 17, just an inch before the foot of page 13, the most powerful and direct of those influences lies in the home. And in almost all cases, however, the measures applied are expressed as a matter of formal or legal terminology. They must necessarily imply working in the closest cooperation with the parents. This ought not to be so only when the child is subject to special measures within the community, but equally when he's had to be removed from home for residential training. And the Commission go on and look at the committee go on and look at the various measures one might apply in fortifying parental or furthering parental responsibility for children. They consider fines and restitution and corporal punishment and so on. And they finally come on page 20, and this is in the addendum, the extra parts, the extra pages that are submitted, to social education and what it implies. And social education is the committee's resolution to the problem. And they say the principle underlying the present range of treatment measures is, as we've indicated, primarily an educational one. And then at the foot of that paragraph, this is especially so with parents, enlisting as it does their active commitment as participants in a process which, for their part, they are increasingly led to see as being in the true interests of their children. Such an approach seems to us to be a proper and appropriate one for the solution of problems of the child within the family. Indeed, we consider the alternative already discussed, based as it is on the view that matters so closely concerns their children are the cooperation of parents as adult persons can be enlisted by compulsive sanctions, is fundamentally misconceived and unlikely to lead to any practical and beneficial results. And then at paragraph 36, just jumping a few lines down, if the conclusion which emerged from the evidence before us was that better upbringing of children cannot be secured by compulsive sanctions on parents, we are also convinced that in various directions the present arrangements do not go far enough in enlisting the cooperation of parents. In some situations appear positively to militate against it. And then further down, just below the bottom of the page, they refer to their experience. We're satisfied the present procedures fall far short of what is desirable in obtaining parental cooperation. So we have a system here which is designed to enlist parents and secure their cooperation. And this is an experienced family court sheriff, and with my submission, what he's done is entirely consistent with the whole ethos of the system his order addresses. Now, that's the domestic part of my argument. But in addressing this first proposition, in my submission, it also requires it to be addressed by reference to its convention effect.
So is this chapter 2, is it?
This is chapter 1 still.
We're still on chapter 1.
Yes. In my submission, there are two parts to chapter 1. One is the domestic law part, which I've now dealt with. But in my submission, if one looks at the convention effects, the argument really becomes overwhelming. And I did submit this to the division under reference to W against the United Kingdom, which is at tab 72. This is now rather an elderly case, but it arose from the days in England and Wales when a care order was made or assumption of parental rights was made, and a parent could not get into the process to ask for contact with their child, and complained about this to the European Court of Human Rights. And the issue was, are there any procedural requirements inherent in rights under Article 8? And that was decided by the court in the section from page 47 and onwards. As my lords and my lady will see from paragraph 57, the court's judgment doesn't relate to the merits of any contact decision, because that wasn't the issue raised. The issue raised was the ability to go and ask for contact and to be involved in decisions about contact. The general principles are set out at paragraph 59, and the issues in debate then appear at the top of page 49, but perhaps for the present purposes, the nub of it is at the foot of page 49, where the court says it's true that Article 8 contains no explicit procedural requirements, but this is not conclusive of the matter. The local authority's decision-making process clearly cannot be devoid of influence on the substance of the decision, notably by ensuring it's based on the relevant considerations, is not one-sided, and hence neither is nor appears to be arbitrary. Accordingly, the court is entitled to have regard to that process to determine whether it's been conducted in a manner that, in all the circumstances, is fair and affords due respect to the interests protected by Article 8, the right to respect for family life. Moreover, the court observes that the English courts can examine on an application for judicial review of a decision of a local authority the question whether it has acted fairly in the exercise of legal power. The relevant considerations to be weighed by a local authority reaching decisions on children in its care must, of course, include the views and interests of the natural parents. The decision-making process must, therefore, in the court's view, be such as to ensure that their views and interests are made known to and duly taken into account by the local authority, and that they're able to exercise in due time any remedies available to them, and there's a reference to the English Code of Practice. And then partway down paragraph 64. In the court's view, what therefore has to be determined is whether, having regard to the particular circumstances of the case, and notably the serious nature of the decisions to be taken, the parents have been involved in the decision-making process seen as a whole to a degree sufficient to provide them with the requisite protection of their interests. If they've not, then there will have been a failure to respect their family life, and the interference resulting from the decision will not be capable of being regarded as necessary within the meaning of Article 8. Contrary to the government's suspicion, the court considers that in conducting its review in the context of Article 8, it may also have regard to the length of the local authority's decision-making in any related judicial proceedings. As the Commission so rightly pointed out, cases of this kind, there's always a danger procedural delay will result in de facto determination of the issue submitted to the court before it's held its hearing. And an effective respect for family life requires that future relations between parent and child be determined solely in the light of relevant considerations and not merely by the effluxion of time. Now, what I take from that is the very early statement by the court that the right to respect to family life involves or requires an involvement in the decision-making process sufficient to protect the interests of the parent and child. And that is a thought which is echoed through the court's case law. There are two other cases which immediately spring to mind. One could have chosen any number of cases to illustrate this particular point. But the cases which spring to mind are Keegan against Ireland. I'm not familiar with the Keegan case.
Do you have
It's tab 61.
tab reference?
It's tab 61. Keegan involved an unmarried father whose girlfriend became pregnant. The relationship broke down before the child was born, and the girlfriend placed the child for adoption, and the father tried to resist that adoption but couldn't because he didn't have parental rights. And he required to go off to the Irish court and obtain a guardianship order, an order for guardianship, before he could contest. And by the time that order was granted, the child was settled with foster parents, and it was all too late. The part that deals with this in my submission is in the Keegan report on page 362. At paragraphs 49 and 50. Where the court recalls that the essential object of Article 8 is to protect the individual against arbitrary action by public authorities. And I pause there because, of course, we are in public authority action when we're in the children's hearing. There may, in addition to be positive obligations inherent in effective respect for family life. However, the boundaries between the state's positive and negative obligations under this provision do not lend themselves to precise definition. The applicable principles are nonetheless similar in both contexts. Regard must be had to the fair balance that has to be struck between the competing interests of the individual and the community as a whole. In both contexts, the state enjoys a certain margin of appreciation. According to the principles set out by the court in its case law, where the existence of a family tie with the child has been established, the state must act in a manner calculated to enable that tie to be developed, and legal safeguards, that's my point here, legal safeguards must be created that render possible as from the moment of birth, the child's integration to his family. And then there's a reference to the United
That's Marx
Nations
and Belgium,
Convention.
isn't it? That's Marx and Belgium.
Indeed so, indeed so. I could have gone back to Marx. This is a consistent theme. And of course, the theme is also represented in Elsholtz, which was the other case which instantly leapt to mind. And perhaps I should take the court briefly to Elsholtz as well.
I think it's important to recognise that in Dublin, the United Kingdom, an element of the procedural safeguards was that you can't address the question of the proportionality of the interference unless you involve the parents of the child at an early stage. So that the procedural safeguards are required so that when the evaluation comes to be made as to whether or not this interference is justified, their input is sufficiently catered for.
One doesn't even get to the proportionality argument until they're there.
Yes, quite. Well, you can't make a proper judgment on proportionality
Precisely.
if you haven't got that input.
And I'll come to that in my compatibility argument. But I'm grateful to my Lord. Elsholtz is at tab 59.
Where are we going to?
Elsholtz, tab 59. I was just going to take this trio of cases to support my proposition. And Elsholtz, I think, possibly starting at paragraph 43, which was the court's assessment of the Article 8 complaint in Elsholtz.
This is an unmarried father contact case, isn't it?
It's an unmarried father contact case, and there were two complaints in this case. One was that the court didn't obtain a psychological report, which the father complained was required. And the other was that when he appealed from the district court to the regional court didn't hold a hearing.
Where would you like us to go?
Perhaps having given that very brief explanation is sufficient to go to paragraph 52. The court looks at relevance and then says, however, it must be determined whether, having regard to the particular circumstances of the case, and notably the importance of the decisions to be taken, the applicant has been involved in the decision-making process seen as a whole to a degree sufficient to provide him with the requisite protection for his interests. And that's a reference back to W. It recalls that in the present case, District Court considered it unnecessary to obtain an expert opinion on the ground the facts have been clearly and completely established for the purposes of the relevant civil code. In this connection, the District Court referred to the strained relations between the parents and so on. And that's all relating to the facts. But at 53, the combination of the refusal to order an independent psychological report and the absence of a hearing before the regional court reveals in the court's opinion an insufficient involvement of the applicant in the decision-making process. The court thus concludes the national authorities overstepped their margin of appreciation, thereby violating the appellant's rights in terms of Article 8. Now, my argument to the First Division was that, given that the disputed order, the sheriff's order, gave effect to Mr. Keeney's, the appellant's Article 8 rights, it should be seen as fulfilling that function, and the court should be slow to interfere with it. And I prayed in aid Lord Rogers' speech in Guyton against Godin Mendoza about giving effect to legislation in a manner that's consistent with the convention. And Lord will no longer will recollect his...
I remember it.
Yes.
I doubt if it's engraved on everyone else's.
What was the reaction of the...
Well, the reaction seems to have been that I was wrong to think that interlocutors could be interpreted, could be given effect. It wasn't well received as a submission, as I recall it. It wasn't that the principle was at stake, it was that they thought my application of the principle was perhaps in error, I should be fair to say. But it's a tab 25.
Is this why we get a passage at the beginning where they say an interlocutor has to mean what it says? It's paragraph 58, is it?
I think that's a reference to my submission. And perhaps submission, in fairness, my submission can't have been as clear as I had hoped it would be. But Lord Rogers' speech is at page 595, and it's paragraph 107 that I was referring to, where it's to be noted that legislation must be read and given effect compatibly with convention rights. The use of the two expressions read and given effect is not to be glossed over as an example of the kind of cautious tautologist drafting used to be the typical of much of the statute book. That would be to ignore the lean elegance of that characterises the style of the draftsman. Section 3.1 contains not one but two obligations. Legislation is to be read in a way that's compatible with the convention rights, but is also to be given effect in a way that's compatible with those rights, and so on. Now, my argument was that here we had a sheriff doing his best and making an order that was entirely compatible with the appellant's convention rights, entirely consistently with Section 3 of the Human Rights Act. And given that was the case, that the court should be slow to interfere with that. And respectfully, one might question the authority, the public authority, the principal reporter, who has taken it upon herself to come to court and suspend the order.
Yes.
And that was all I was required to say in terms of my first proposition.
Yep.
And if I might move then to the second part of my case, which concerns the compatibility of the structure that we have, that requires an unmarried father, such as the appellant, who doesn't have care and control of the child, to secure an order in the sheriff court in order to become a relevant person. And before I address that, I need to address a misapprehension about the focus of my Article 8 case. The issue I'm raising in the compatibility argument is in relation to the involvement of the father in the decision-making process. I'm not focusing on the merits of any decision that might result from that process. I'm not concerned with any child protection measures that might be the outcome of a process. And I'm not arguing for unmarried fathers to automatically acquire parental responsibilities and rights. What I'm arguing about is involvement in the decision-making process of the children's hearing. And in that context, it's my respectful submission that there is no question at all of the parent's Article 8 rights competing with the child's. We're talking about access to the process to an extent sufficient to protect the family life of this parent and this child.
And by access, you mean not just ability to observe what is going on, but to participate in the discussion.
I'm grateful. Yes, yes. And effective participation involves being a full participant, so one would have to receive the reports in advance, one would have to be able to discuss, and also one would have to be able to appeal if one thought the children's hearing had got it wrong, appeal having been provided. And if one addresses this in the classic manner in terms of Article 8, one would say, first of all, involvement in that process falls within the scope of Article 8. That's W against the United Kingdom. And so failing to include a parent whose relationship with the child falls within the ambit of Article 8, as this parent does, from the decision-making of the hearing, unless he has parental responsibilities or care and control, does constitute a measure of interference with his right to respect for family life, I would submit. Because it has the effect of including some parents with Article 8 rights, but excluding others. And a man such as the appellant falls outside the circle of inclusion for the purpose of involvement. Now, going on with the analysis, of course, the second part is that in accordance with the law? And of course, it is in accordance with the law because that's what section 93 2b says. And the next question that follows from that is, does that failure to include or effective exclusion have a legitimate aim? And that's where, in my submission, we start to encounter difficulties. It's difficult to see what the aim might be. And looking through my learned friend's case, she perhaps comes closest to her aim in paragraph 40 of the case, when she says the aim is to restrict the numbers of those in attendance at the children's hearing to the persons most closely involved and engaged in the life of the child.
I'm sorry, what paragraph is that, please?
That's paragraph 40 of the respondent's case, the principal reporter's case. It's not for me, of course, to identify the aim, it's for her to identify the aim.
But they're now in anyway, right? They're now in.
Sorry.
The people are, the person in
Yes.
the appellant's position would now be crowding into the room. Is that right? No,
No, he wouldn't. No.
not under the new act.
No.
Oh, right, sorry.
I'm sorry, I'm cross
Well,
purposes.
it's a change in 2006.
No, this person would not be in because under the 2006 Act does not operate retrospectively.
No. But nowadays, people in his position would be in.
If they had registered the birth, but of course the mother controls the registration of birth, and if the mother doesn't permit the father to register the birth with her, then he wouldn't have been in.
But this man did register birth, didn't he?
He did, but before the 4th of May 2006.
Yes.
Quite.
A person in his position,
Yes.
supposing that the role of the film on would be in. So the very reason you already said one of his children would, in
Yes,
respect.
And that's obviously relevant to the examination of the legitimacy of the aim.
Yes, precisely, and the proportionality of the aim.
Exactly.
Yes, quite. I'm so sorry, yes. But my question is whether to limit involvement so as to exclude a class of persons with Article 8 rights could ever be a legitimate aim in terms of the Convention. If one looks at the terms of Article 8, the only basis for a limitation would be for the protection of rights and freedoms of others. That would be the only possible basis. One has to raise the question, whose rights and freedoms are at stake so as to require the exclusion of a man such as the appellant from the children's hearing?
Well, the answer to that seems to be, if you look back at paragraph 40, second last sentence, that you restrict access to the hearing to those who have the ability to implement decisions. So you can, the suggestion seems to be that you can take an a priori view and you can say, well, there's some people who on no possible view of this case could ever actually be in a position to implement a decision. Why should they be there? Let's concentrate on the people who are really in play as people who could implement the decision. That seems to be, I hope I'm not representing it, that seems to be the other side of the argument.
Possibly, but then if one's looking at Article 8, one's saying that there are certain persons who have a right to respect the family life and a right to the mutual enjoyment of society who may not just at this very moment have that, but still have the right to respect for that, and who are excluded from that circle of involvement.
Well, is that a convenient point at which to break until 2 o'clock? Well, we look forward to seeing you at 2 o'clock.